Mr. Nomclain, good morning.
Good morning. If it may please the Court, I think I could maybe assist the Court because obviously, as you recognize, these two cases bleed together. Despite what the AG might say, the sky is not falling if you rule in favor of Mr. Coffin and Mr. McIntire. We've already have case law that answers the bright line question. We have Lynch and Lewis and DuPont, the cases cited in the parties' briefs, that really instruct the proper application of policy. In Lynch, we have an escape case. And the fact that you can't self-help and escape is an ancient rule. It's been cited in many law. It's been around for a long time. So, even though you may be entitled to release, you still have to behave yourself in the...
Mr. Nomclain, I don't think that's in this case either, and we really don't have to dwell on it.
Right. But I just want to say that those cases do answer the question as far as what's the difference. I mean, would a prisoner then be able to, beat a correctional officer and get away with it? No. I mean, there's a difference between being... Lewis and Lynch tell us that you still recognize de facto custody for certain circumstances, like recognizing dead time and escapes. And I think the DuPont case sort of shows it the flip side, where a person wanted to get credit even though he had committed a crime while in custody. And again, there's another policy where we wanted to deter people in custody from misbehaving. So that's really what's behind that.
Okay, but respectfully, don't you have actually a quite different argument from the previous case, in that in the previous case the issue was the individual a prisoner, and you need to be a prisoner only because procedurally you must be a prisoner at the time that the Section 12 petition is filed. In your case, you look to the definition of who a sexually dangerous person is, and your client was found SDP based on subsection 3, which includes as part of the definition of SDP that he was previously adjudicated as such by a court of the Commonwealth. And I understand your argument to be he's not SDP because he was not previously adjudicated. That's a different argument because being a prisoner is not part of the definition of an SDP.
Oh, you're right. I mean, there's certainly that difference. You're absolutely. I think my case is one where you have an individual who's been found not SDP by law, as a matter of law, and yet he's still being held for a decade by the government.
Mr. Nomclain, I think I know the answer to this, but initially there were two qualified examiners who said he was no longer dangerous, and there were two experts that he called who said he was no longer dangerous, correct?
That's correct, Your Honor.
And then at some subsequent time, somebody else said he was still dangerous.
Well, the cab board said that.
I understand that.
Right.
Had he committed any other offenses?
He had nothing. While he was incarcerated, he was convicted of an escape.
No, sexual.
No, none. No. Basically, he was committed about 20 years ago, in 2002.
I thought I was correct about that. So that in essence we're back to the two qualified and two experts who say he wasn't sexually dangerous.
Right. It's a very straight up Johnstone type of issue where under the statute he can't be.
Could he have just walked out?
No, of course not, Your Honor. I mean, to me, that's an absurdity because nobody can just walk out of prison. We have all kinds of considerations of the safety of the guards, of other inmates. Self-help is plainly in the law.
And nobody's made that claim. Nobody.
No.
In your case, not the client's
Well, I think the Commonwealth tries to think that it's an issue, but it really isn't. And
Can I ask you this question? I'm just trying to understand procedurally. You're complaining about the 2002 SDP commitment, correct?
Yes.
And that was a Section 9 proceeding.
That's right.
He had previously been committed as an SDP person.
Yes.
And so the Section 9 proceeding, there were the two QEs said he's not sexually dangerous, and two private psychiatrist said he's not sexually dangerous, and the Commonwealth called the CAB person, the community, what is it called?
Community Access Board.
And that person said, no, he is. And today, that would not be sufficient, right?
It wasn't sufficient then.
So, but in 2005, he had been previously adjudicated as a sexually dangerous person long before 2002.
But I think that you have to read the statute for it to make sense. I mean, why would you still be doing a Section 9 when your guy wasn't previously adjudicated? I mean, you would never, that language would never.
But what's the difference between a Section 9 and an original commitment?
Well, you're originally committed. You say you're a prisoner coming out of the correctional system, and you're sitting in prison, and they file a petition against you, and they find you STP. Mm-hmm. Now, when your Section 9 rolls around, you file Section 9. Obviously, you've been previously adjudicated STP.
Yeah, as he had been here. Leave the 2002 Section 9 proceeding aside. He, in 2005, in 2008, in 2010, all of his
I would disagree, Your Honor, because you cannot read the statute to say that having been previously adjudicated not STP, as a matter of law in 2002, that he can then reach back to his original commitment and say that's the adjudication the statute is referring to. Because where would there ever be a difference? I mean, that would never apply if you had a guy on the outside. If a guy coming off the street previously.
But don't you have a problem here, though, where unlike Mr. Coffin, you've got an interpretation of a statute in 2009, but it wasn't based on constitutional grounds. It was based on reading the language of the statute. You have a civil judgment in 2002. I think there was no appeal, correct?
The 2002 case?
Yeah.
Well, this is the appeal of the 2002 case.
Oh, okay. I'm sorry.
Yeah.
But you have a civil judgment. It's still in effect. The judgment is in effect until it is appealed, and then you have these subsequent events. So you don't have a
We do have a constitutional issue. Under the substance due process law, since the common law, it's an ancient rule, once a person is found lucid, he must be released. It's a matter of decency to do that. I mean, it would be shocking to hold somebody if they're not dangerous or not sick. I believe part of the substance due process clause under the 14th Amendment is that once a person is found not to be dangerous, you have no power to hold him.
Hold it. You're saying he's found not to be dangerous because later a court has said the way the statute is written means that you need at least one person who is a qualified examiner to say he's dangerous. That's different than saying sort of as a matter of
No, it's exactly the same. You just said it, Your Honor. The statute as written says as a matter of law he's not dangerous.
But it didn't say it as a matter of constitutional principles. It was a statutory interpretation.
Once the state has said once the statute is set up to make a framework of how we're going to decide someone's not dangerous, and you've executed that framework, and the framework tells you the person's not dangerous, it becomes a constitutional issue.
Well, then what about a judge who gives an improper jury instruction and it's reversed on appeal because as a constitutional matter, he didn't, the statement shouldn't have come in, and the judge ruled improperly that the statement should.
I think it's different. You have like a purely legal issue, legal error, as opposed to an absolute jurisdictional error, where a person, when they're found not dangerous, the state's jurisdiction ends. You have no reason to hold that person anymore. And I think, as I lay out in my cases, and look at the Norman case. Norman's case says, once you've lost jurisdiction, total jurisdiction, then even the trial itself becomes a nullity. It would be as if he wasn't tried at all.
Would he have been found not dangerous? The Commonwealth simply could not have proceeded because they didn't have a qualified examiner.
Right.
He would never have been found not dangerous.
He was found not dangerous as a matter of law.
No. But because of our interpretation in Johnston, that only said that at least one of the two QEs must agree that he's sexually dangerous.
Right.
Remains sexually dangerous. But and so if there isn't any QE who will testify that he remains sexually dangerous, he isn't found not sexually dangerous.
He is not sexually dangerous as a matter of law. The judge has no option but to release the man. If this was any other
but that's not a finding. You keep saying he was found not sexually dangerous. There is no finding that he wasn't sexually dangerous.
If you look at, for instance, if you look at like the old section, the old civil commitment statute seems to be much clearer on this point. And not under the old statute, which I think I have in my addendum. It basically says if the two psychiatrists find the person not dangerous, then the court shall order him discharged. So the judge has no other power than to discharge the individual at that point. In any other civil case, this case would have been ended by summary judgment. So, I mean, in this sense, what could the court do other than release the man? And it didn't. It failed to do so.
The case ends in summary judgment. That doesn't mean the court didn't have jurisdiction. I mean, you keep saying the court has no jurisdiction.
You have no jurisdiction to enter a judgment of committal. You have no judgment to commit him was illegal, ab initio. The court had no power to put him back into the treatment center.
Well,
Yeah.
go ahead.
I mean, what power would you have if the person's not dangerous?
If we may have some flexibility here as to whether or not to disregard the effect of the first judgment in this case, as to whether or not the subsequent SDP proceedings cannot rest upon the invalidity of that judgment.
Right.
We may have some flexibility. What is your most compelling reason for us to say that we should disregard any validity that first judgment may have had?
So the initial petition?
Yeah.
Because under the statute and under the substantive due process clause, once an individual is found to be not dangerous, then he must be released.
Well, let me ask you to give me an equitable reason other than the one you just gave.
Because as a matter of equity, it's not fair to subjugate somebody to jurisdiction or commit, incarceration and the corollary and concomitant results of that when that person should not have been incarcerated in the first place. It seems to be abhorrent that you would have, you would subjugate this person to commitment for 10 years when he should have been released in 2002, and he's forced to, basically the only legal, which he did file, legal recourse is to file subsequent Section 9s. And the fact that he did that and lost, again, I would say is a nullity because he was found not dangerous in 2002. He should not be punished for trying to follow, to resort to the only way he knows how to get out.
If he had struck a guard, would you be making the same argument? If he had been struck a guard and charged with assaulting a guard, would you make the same argument?
No, of course not.
Why not?
Because, again, under the Lynch cases and cases like that, there's a difference between what happens when you're just in the custody, when you're a prisoner as a matter of fact, as opposed to a matter of law. We're not going to propose that prisoners who should be free have the right to strike the innocent officers that have been charged with their custody. That's just not it's not a good idea, and it's not what the case law demands. I mean, Lewis and Lynch and DuPont all tell us that that's not what that principle is all about.
Mr. Van Klein, isn't, in answer to Justice Spina, isn't at least one of the considerations here is that, which goes to the overall structure of the statute, which I think is reflected in Johnstone, that I don't know what the case would be if during the period of time that he remained at the treatment center, after he was found to be sexually dangerous on the basis of the CAB view as opposed to the experts' views, and had then committed another sexual offense while in the treatment center. He had sexually assaulted somebody that was consistent with this. I don't know what we do with that.
Well,
but isn't the issue here that he hadn't committed any other sexual offense, and so essentially what you have is a further proceeding where somebody disagrees with CAB, disagrees with the four experts?
Well, I mean, that's certainly what happened in the 2002 trial. The CAB disagreed with the four experts, but the CAB, as you said in Johnstone, has no legal significance. It's the QEs that do. Now, if he had committed a sexual crime while he was incarcerated, and in that serving the sentence for that crime, the Commonwealth had filed a petition against him, I would have to concede that that might be a valid way to regain jurisdiction, but that's not what happened. That's not even, that's not nowhere in this case.
So you're saying we need to set aside the SDP judgment of 2002 and then also set aside all of the subsequent SDP judgments because they followed from the illegal commitment.
Right. I mean, you don't have to, the appeals court's already vacated the 2002 judgment.
Right.
So, yes, I mean, basically, since they had no jurisdiction to hold them ab initio, any concomitant corollary process after that is void, is a nullity. And there's plenty of case law that tells you that is within the court's power.
And it's a nullity because he was not a previously convicted sex offender? Or
Yeah,
SDP?
under the statute, he wasn't previously convicted, that's right. And also as a matter of substitute process, he should have been released as a matter of law.
Thank you, Mr. Namclean.
Thank you.
Good morning, Mr. Mansfield.
Good morning, Brian Mansfield for the Commonwealth. As an initial matter, this court need not even reach the voidable argument, specifically because Johnstone, or the decision in Johnstone, need not be applied to this case retroactively.
But this is the direct appeal. I mean, this is a case on direct appeal.
But it's not a constitutional case. This is a new interpretation of an existing statute. The case law, as I've read it, says when it is not a constitutional issue, you must either preserve the right for trial. Actually, even when it is a constitutional issue, you must preserve the right at trial or fall under the clairvoyance statute. But this is not a constitutional case. Johnstone simply supplied or clarified what source of evidence the Commonwealth needed to provide to make a prima facie case.
The appeals court rejected that argument, correct?
Yes, they did.
Saying, hey, this is the way the statute was interpreted, and that's what it always meant.
That's what they said, although this court in Johnstone said it was clearly changing prior practice, and it was deviating from what had been the norm.
Practice is one thing. Right? In other words, nobody's doubting that the Commonwealth was proceeding in good faith under its interpretation of the statute.
Yes.
So the practice was there.
The practice was there, and for the CAB had always, or practically always, been called as an expert witness in Section 9 proceedings. And as a matter of fact, the predecessor board, the Restrictive Integration Review Board, had also been called as expert testimony. And it wasn't until much later that somebody questioned whether one of the qualified examiners.
Somebody read the statute.
Yeah.
Under the statute, yes.
Our case law says that when we announce a new interpretation, we don't have to apply it retroactively. We can.
You can. Correct.
Why shouldn't we in this case?
One,
I mean, why shouldn't we also take into consideration that the defendant's appeal took place while I just forgot the name, Flintstone, Johnstone. Struck a flame, yeah, in our jurisprudence. Why doesn't he get the benefit of that case while it's on appeal?
because it's not a constitutional rule.
But it doesn't have to be a constitutional rule.
Doesn't have to be a constitutional rule, but this is not an issue that was preserved at trial. This was not an issue that was even preserved in the first motion for a new trial, which came in almost 5 years after the trial. The trial was in June of 2002. In January of 2007, the petitioner, McIntire, filed his first motion for a new trial, and this issue was not raised in that motion. This issue was not raised until for another 6 months in July of 2007 in an amended motion for a new trial.
But you would also say, I take it on your side, well, 3 different adjudications have happened in the meantime, all of which have found him to be an SJC.
Correct, and all of them with qualification.
Could you help me out?
Yes.
Maybe one just has a different view of experts. But it seems to me that one thing about the statutory scheme, at least one could read the statutory scheme to say, and in fact under Hendricks and other pretty compelling United States Supreme Court constitutional process, you're allowed to keep somebody committed when they're not serving a sentence, and you can keep them for a very long time but they have to be sexually dangerous. And you have to provide, probably constitutionally, an opportunity for that person, somewhere along the line, the legislature said once a year, that they can come in and say, I was, but I'm no longer.
Correct.
Right? And there's a determination, he is or she is no longer. And then for whatever reason, timing, there's a mix-up, not well represented by counsel, a variety of things. The Commonwealth has another opportunity. The behavior hasn't changed in any respect, as far as we could tell, sexually. And all of a sudden, the Commonwealth comes up with another expert who says, oh, I've looked at this and my view is different. Doesn't there seem to be something that's not quite consistent with what the Constitution requires?
No, at the time, the Community Access Board review and the Qualified Examiner reviews were contemporaneous.
No, I know that, but I'm trying to, there are other circumstances where somebody might have had another Section 9 hearing and might be under these set of circumstances, right? In other words, you can conceive of a situation where somebody is, to use, one of the examples in the prior case, somebody doesn't realize that their first Section 9 proceeding is invalid because there were no qualified examiners who said the person was sexually dangerous. There's another Section 9 hearing, but there's been no change in behavior. There's been no further sexual conduct.
That's true in this case, yes.
Yeah, and there may be other cases. Isn't it a little bizarre for us to be saying, well, the next one is okay because there was no change in behavior, but just a new group of experts have said, actually, we think he is still sexually dangerous.
But there was no change in behavior, but there was also no change in the evidence that the jury got to see in 2002 as to why he was sexually dangerous. This jury didn't pull this verdict out of the blue because of bias or fear.
No, I understand that. I'm just looking at the procedural mechanisms for what we're doing here. We're saying, while somebody's sexually dangerous, you can hold him, but there has to be an opportunity that you can show that he was not sexually dangerous. He showed that he was not sexually dangerous.
He did not show that he was sexually dangerous. The jury returned a verdict that he was sexually dangerous. It wasn't until later that this court in Johnstone said that the Commonwealth must have one of the qualified examiners in order to meet its prima facie case.
I understand that, but you've got 4 people saying he's not sexually dangerous, so shouldn't even go to a jury.
Well, if you read the transcript, Your Honor, you'll see that the experts in the original trial who found Mr. McIntire not sexually dangerous did not comport themselves well. There was another basis for that jury to find as they did. Mr. McIntire has admitted up to 100 offenses. All 4 of the experts, or 3 of the 4 experts that said not sexually dangerous, all ignored that fact, although all 3 of them in prior reports had said that he did have 100 offenses. So there was...
My point is not the specifics of this case. Experts may be good, they may be bad. You may disagree, you may be able to find a perfectly good expert sometime later, but I'm just looking at the process of saying, unless you can get 4 experts, unless you can get 1 expert,
Right.
and for whatever reason, the Commonwealth didn't. I'm not faulting them.
Well,
maybe they didn't think they had to because CAB was going to do their whatever it is. But if you couldn't proceed then, it seems rather strange that you can then...
Well, regardless of Johnstone, the Commonwealth contends that the board still can provide expert testimony. And Johnstone doesn't say that the board cannot provide expert testimony. What it says is that one of the QEs must. But once one of the QEs says sexually dangerous, there's no limit on what type of testimony the Commonwealth can add to that qualified examiner. And so the Commonwealth can still call the Community Access Board as an expert to complement. And in fact, in this case, and as was the case in Johnstone, all the members of the board were qualified examiners. The only difference is it was a board rather than one individual person. But the board was an expert. Now, according to Johnstone, it wasn't sufficient evidence because they didn't have one of the qualified examiners, but that's just an evidentiary issue. It's not a constitutional issue.
So what would have happened? Let's assume Johnstone was in effect in 2002.
Yes.
The petition simply would have been dismissed.
It's not dismissed because it was the petitioner's petition under Section 9 to be discharged.
All right. Okay,
And
very good. So the petition would be allowed?
we would still have to go to court. The court still retains jurisdiction, in contrast to what the petitioner claims in his brief. The Superior Court still has jurisdiction. The Superior Court still must enter a non-sexually dangerous judgment before release.
Is that what the court would do, would simply enter a not sexually dangerous judgment?
Yes, either on motion or a directed...
And order release.
And then order release.
So let's assume
They
that...
must order release at that time, correct?
Yes. If he's not sexually dangerous, then they must order release, yes.
Let's assume that happened in 2002. I take it in 2005, the Commonwealth could not file another petition unless there had been something happening between 2002 and 2005.
Well, if that had happened in 2002 and Johnstone was a decision prior, he would have been released in 2002. There would have been no reason for him to file a petition.
No, but there'd been no but could you bring a new petition saying, well, he really was sexually dangerous, and although there's been no conduct between 2002 and 2005, no illegal conduct, we think he still is, so we're going to bring a new petition.
Well, that would have followed him under Gillis. He wasn't serving a criminal
Let's assume
sentence.
he's serving a criminal sentence for breaking and entering or
And
something.
he remained in prison for
Yeah.
a period after 2002.
Right.
The Chapman case says, yes, the Commonwealth can file a new petition, and that's all. It does depend on his current status as a sexually dangerous person.
Okay.
But in that case, you're proceeding under the SDP definition 1 or 2, not 3, correct?
Correct.
Okay.
On a
Now,
new
in this
petition.
particular case, I gather you proceeded in 2005 under the 3rd definition.
Correct.
That's correct.
And am I correct that the previous adjudication, which was used in 2005, was the 2002 adjudication?
No, it's actually the
1984.
original commitment.
It was 1984, so that was viewed as the original. That was viewed as the previous adjudication.
Yes.
It was 84, not 2002.
Correct.
2002 was a Section 9
It was a
proceeding.
Section 9. He was found to remain dangerous.
No, but in 2005,
The previously adjudicated was the 1984.
1984.
and your position is that, however, if the 2002, as Justice Cordy asked, had interrupted it, then you still could not have proceeded anymore under Section 3. You'd have to proceed back to Section 1 or 2, even though you had a previous adjudication.
Correct. Because he had then been found, there would have been an intervening not sexual.
Now, what do you say about the dilemma? I mean, if you prevail here, it raises a dilemma for SDP petitioners in that, having been found SDP, they now have to decide, am I going to appeal my SDP adjudication and hope to win, or am I going to seek a new SDP hearing within the 12 months, because if I happen to lose that next one, it will moot my appeal? Isn't that a problem, or is that just basically a petitioner's dilemma?
It's a petitioner's dilemma.
And do we know how fast Section 9 proceedings are taking place in the Superior Court?
2 to 2.5 years is
They're
the
not
average.
taking place within 1 year, correct?
No, and this court's never said they had to under the Trimmer case. The statute says they may apply or petition for release once in every 12 months, but this court has said that doesn't mean they get a trial once in every 12 months.
Is there any other instance you can think of in which a second proceeding may moot an appeal, apart from what you're asking us to do here?
It's not saying it moves
I'm not saying it's moot. I'm just saying that judgment, as with the
Justice
appeals
Gans
court-
is asking you the flip side of the appeal might moot, the Section 9 might moot the appeal. He's asking the flip side.
Basically, if I'm a petitioner and I apply again and lose, it doesn't matter whether I win on the appeal if you're right, because the court will say, congratulations, you won on the 2002 appeal, but you've been adjudicated SDP again in 2005, and so you remain where you are.
I I think that may depend on whether it was a constitutional issue that was...
Wouldn't it also depend on factual circumstances, so that if in fact, not on some statute of limitations, but the court decides that in fact he was no longer dangerous, that's the final judgment in 2002, and there has been no further sexual conduct. Isn't it a little bit odd to say, well, you prevailed, you were, I don't want to use guilt innocence, but it's close, because it's incarceration, and we just get another go at you, even though you're doing it because you're hoping to expedite the matter, because the legislature's given you a right to do that.
And that goes right to the issue that was in the Coffin case, that once that appeal, as in this case, that judgment was voidable, only voidable, which meant that in 2005 and 2008, he was still validly civilly committed as a sexually dangerous person. Any subsequent judgment, as in this case, just at best was voidable and not void ab initio.
Okay, but the fact remains that if this petitioner had chosen to wait until he heard the results of his 2002 appeal before he decided to apply again, he'd be on the street today.
Possibly.
Well,
How not?
one wouldn't posit that the normal appeal is going to take 7 years.
And
However-
part of that was he filed that motion for new trial. But if this appeal had progressed more swiftly, this issue never even would have been raised. It's actually, the only reason this issue's here is because of the delay in the appeal.
And sometimes we have to deal with issues of equity because of that.
Again, it's, he has, the key is that he has been found sexually dangerous currently in 2005, 2008, and 2010. And I acknowledge the 2010 adjudication came after the appeals court decision in this case. But it's the current presentation as sexually dangerous that's important. So the fact that we can go right back to the fact that this judgment was voidable at best, and he was validly civilly committed, never having been found not sexually dangerous at the time of the 2005 and 2008 Section 9 trials.
Thank you, Mr. Mansfield.
Thank you.